everybody. Welcome, and thank you for joining us today for the third of 5 webinars this week that we're doing for our 32nd annual Employment Law Update. My name is Britenae Pierce, and today I'm going to be talking to you guys about employee termination best practices during COVID and beyond. So lots to cover here, and in the past I've talked about this a little bit before, and I'm going to take a little bit deeper dive into some of the issues that come up. The thing about terminations is they just aren't ever fun. Most people don't like doing them. Definitely the employee does not like being terminated. So it's really tough, and there is a lot to think through, and that's why we're talking about this now, about all the things that you should be doing and thinking about, so that way you are prepared when it does come time to terminate someone. So just kind of the base starting point in Washington, and all the stuff I'm talking about today is mostly, it's Washington based, so different states might have some different considerations, so keep that in mind. But here in Washington, employment is generally at will. So that means that you can terminate an employee for any or no reason as long as it's not based on discrimination. And that means you can't even have, part of it, some piece of it based on discrimination if there's also a legitimate business reason. You really need to have a legitimate business reason for terminating without any discrimination involved. When you are approaching a termination, be sure to think through the process first. You don't want to rush it, of course. We'll talk about when there are times that are emergencies where you do need to do that. But in general, for most terminations, you shouldn't have the, oh geez, 9:01 a.m., I need to terminate by 9:02. Really shouldn't be like that. You should be thinking through the process, and we're talking about today things to be thinking through. I put due process on here. It's not, due process maybe in terms of, constitutional due process or something, but really just think about in your organization, how you're treating people, and is this the right approach? One example is that if someone, one of your employees has made a claim for harassment against another employee, don't immediately terminate the other employee. That, while maybe that's where you're going to end up, you need to investigate first. You need to consider what's going on, interview the witnesses, things like that. So don't jump to termination as your immediate result. Think through what should be done in every different circumstance. You should also be considering alternatives. Sometimes termination isn't the best choice, and it's maybe not the best choice because you don't really have support for it, or because there would be an alternative that could be better. And we'll talk about, for example, performance improvement plans in a minute. So there might be options to try and help the employee or help your business before you even get to termination. And thinking those through and thinking through the options is helpful. Sometimes it can just be a warning. It can be some, verbal written warning, some limited discipline before you get all the way to termination. When you do get to the point of terminating, you just want to make sure you're treating your employees similarly and fairly. So for example, if 2 employees have the exact same violation, you shouldn't terminate one and do nothing for the other. You should generally be treating folks the same. And that is really for 2 big reasons. One, because it's the right thing to do. And second, because if later you have to defend that termination, you're going to want to be able to show that this is how you treat similarly situated employees in these types of circumstances. And you don't want to say, yeah, this was a real outlier. We just decided to terminate. Because guess what? They might be bringing discrimination, retaliation claims. So to the extent you're treating employees similarly, that's a very helpful defense for an employer when facing potential claims from that terminated employee. Also, what if the employee made some sort of recent complaint? That's a problem. You can still terminate, and there are circumstances in which you can do that. I will say the presumption is often for retaliation if you terminate straight away. The general rule of thumb is the longer period of time between the complaint and the ultimate termination, or even discipline really, is better for the company, so it doesn't look like it's retaliation. Now there are some exceptions, and I'll talk about that, where if you've made the decision in advance of the complaint, that's great, or if there are other considerations, you can do this. but something to be thinking about, and certainly when in doubt, something to be reaching out to your counsel about, because this is a pretty sticky area and you really do want to be careful for those employees that have made complaints. For all of this, when thinking through whether to terminate and how to terminate, really keep in the back of your mind, what would someone else think? And I just put a judge or a jury here because that's what I tend to think about. Any documents you have, any actions you take might end up being put under a magnifying glass. And so you'll just really want to be careful and say, does this pass the basic smell test? And sometimes that'll be like, this just doesn't feel quite right. And then you'll want to go back to considering those alternatives and seeing what you can do. Oh, document, man, we do love to talk about documenting. And I was listening to Kristen's presentation on Monday. She certainly raised that a couple times there about how important it is to document. So I gave it its own slide today. You want to document any complaints about the employee, any warnings you've given the employee, anything that you have done that is leading up to support your reasons for termination. So sometimes it can be as quick as a short email. It can be putting a note. Now that we're much more digital and less paper, keep it in your electronic file for the employee, but you should be doing it contemporaneously. You don't want to go back and recreate the past. You really want to, in the moment, jot down, hey, so-and-so made a complaint about so-and-so's work, and say what it was and what you did and what the problem was, and keep that. So that will help you. I can't tell you how many times we talk with companies that are ready to terminate an employee, and the only evidence they have in that employee's file are glowing annual reviews. And it's like, okay, there's a real disconnect between why you're now wanting to terminate and what is documented. So you need to help yourself by documenting appropriately any problems, so that way you can use those as support for the termination. Of course, any documents need to be done professionally. I know that goes without saying, but even your short emails, short notes, again, you don't know who's going to see them later, so keep that in mind. And I alluded to this one before, but documenting when you first decide to terminate is particularly important if internally you've made a decision to terminate an employee. The employee gets wind of something like, they don't think they're being, they think they're going to be shown the door soon. And so guess what they do? This happens a lot. The employee will all of a sudden make a complaint of harassment, of discrimination, of who knows what, some kind of complaint. And then now you're like, oh geez, how do we terminate this employee now when they've just made a complaint? If you've documented it internally that the decision was made before that complaint, that will help you. So please do keep that in mind for the documentation purposes. PIPs, I mentioned these too. What is a performance improvement plan? Basically, it's a kind of a plan or agreement that the employer and the particular employee enter into to say, hey, employee, things aren't going great. We've got some problems and we need to improve them. So let's get a plan going. And your plan is going to say, here are some concrete things we need done. We need you to improve on meeting deadlines, in the quality of your work. We need you to improve on your communication. You aren't responding timely to emails. Whatever it is, you're going to lay out some of these things, and you're going to lay them out specifically, and you're going to give a deadline for improving. And these are not to be used in every circumstance. They're worth considering whether you should use them. So if you've got an employee that just isn't doing great, maybe you're not ready to pull the trigger on termination yet, feel like you really should give them a chance, this is a good option for you, because then you're being very clear about the expectations, and what's going to happen if they don't meet them is that they aren't going to keep working there. So it gets everyone on the same page real quick. It's not appropriate to use these when someone has already done something egregious enough or violated a policy, or there's just no hope and you just need to terminate. So think about whether they're appropriate. They can be a useful tool. And in some cases, they're also a good tool for kind of building that support for ultimately terminating an employee, if you think that's where you're heading, and especially when you don't have a lot of good documentation or a lot of good support leading up to it. What happens if you do enter into a PIP and this employee is just bombing left and right and not improving? Do you have to wait the full period? The answer is generally no, unless you've put something in your PIP that says otherwise. If you make some sort of guarantee to keep someone for an additional 6 weeks or 12 weeks, whatever the period you've decided, you would have to abide by that. So don't put that in there. So otherwise, if someone is just really failing, you can let them go earlier. And I generally recommend that in any PIP that you give yourself some wiggle room. So basically you should have some language in there that says, we're going to review on this date, 6 weeks out, if there are any issues in advance, we will make decisions and discipline and potentially terminate prior to that. So keep that in mind as well. Okay, hot topic. Who doesn't have questions about this? This is tricky. We've worked with a lot of folks that are doing terminations during COVID, and the first question is always, can I do this? Answer, yes and no. But let's go with the yeses first. Yes, nothing about COVID or people working from home in and of itself stops you from terminating employees that are not performing or that are not following company policy or that are otherwise, doing things wrong, that you would be terminating in any normal circumstance. So you do have to be a little careful about these things. If they are, for example, working from home or you don't get to see them or know what's going on, you'll want to have a little more check-in, make sure that you have a good basis for terminating. And as I said here, focus on objective business reasons. So, the person just flat out missed deadlines for filing reports or whatever it is that have nothing to do with COVID, you're on much firmer ground, of course. There's, other circumstances where it's not so easy. And, I talked about high-risk employees, or I mentioned that down here. And Hannah yesterday in our seminar, she went through this in much more detail. So in case you missed that, I'd really recommend going and grabbing the slides from her presentation because it talks more about what the high-risk employees mean and what you need to do. But I just want to point it out here that right now we have an ordinance for high-risk employees. Basically, you can't force them to come to the office and work. You should be terminating them in any way for their not coming to work. And so this is going on indefinitely. There's no end date for this ordinance yet. So just keep that in mind. You also do have to have a safe workplace. OSHA requires that. So you can't have employees who don't show up to work because it's unsafe and then you say, you're fired, you're out of here. You do have to have a safe workplace and you do need to keep that in mind. What about when you've got employees that have been working remotely, your business is opened back up and they are essential and you need them to come into the place of work and they refuse to do so? Can you terminate them? This is kind of the big question. And short answer is, if they aren't a high-risk employee and I put down here, you can see, this alphabet soup, the FFCRA, FMLA, all of that stuff. Look to those things, make sure you aren't, violating one of those categories. But I'm going to say, assuming you are not, they aren't high risk, there's no other reason, you do have a safe workplace, you've implemented all the appropriate measures. Is there a basis for them not to come in? There's really not. So ultimately, yes, you probably can terminate them. I generally recommend walking through the options with the employee before you get there. So what are their concerns? See if you can explain why their concerns have been addressed, the safety measures you're taking. Let them know that if they're refusing to show up, then ultimately you're going to have no choice but to let them go. And talk through options, of course. Talk through, can they still work remotely? Consider what you can do. I just generally recommend being cautious in this area because, the COVID lawsuits are just starting. We know there are going to be more of them. You don't want to be in one. So make sure you're thinking through all of that first. And when in doubt, please do talk to your counsel because there are a lot of specific situations that you should be aware of and careful about terminating in this type of circumstance. Layoffs or reductions in force, it's a different type of termination. We're mostly talking about terminations for cause or things like that. But of course, layoffs are happening. Lots of the folks on the phone have probably done them. Some people are still going to be doing them. So considering alternatives is very helpful. So there's, shared work program. You can reduce hours. You can, in some cases, you can reduce salaries potentially. So consider if there are alternatives to keep your workforce intact. Sometimes there just aren't. And so if there aren't, you do have to do layoffs. And so in that case, it's tough to figure out, well, then who do I lay off? You really need to be looking at objective, non-discriminatory criteria. Don't go with the, hey, let's just let go of the people that are the most expensive employees so we can save more money, because guess what? Those are usually the people that have been there the longest. They're usually the oldest. You don't want to have an age discrimination claim on your hands. So think about, the appropriate skill set, the positions. Sometimes it's, you just have to do it by department or something like that. But you really want it to be a very objective basis so that way you can support it later. So the person you've laid off isn't saying, this was discrimination. And you can say, not true. Here is exactly why. Here's the criteria we used, and make sure it's supportable and documented internally. Warn I mentioned here as well. So this doesn't apply to everyone. It's really for larger companies with over 100 full-time employees that are doing a massive layoff, a plant closing, something like that. In this scenario, you have to give 60 days written notice. So just something to keep in mind if you are a company of that size and doing a bigger layoff, you might have to jump through some extra hoops here. I'm not going into all of them, just want to make sure you're aware that that's out there, just in case that applies to you. Okay, what about requirements for employees when you're terminating them? So we've talked about Washington law is at will, so generally you can terminate. Washington doesn't require things like payout of PTO, but even though the law might not require that, your company might. You might have an employment agreement or in your handbook or a collective bargaining agreement that has some different terms. So this is, one of the reasons that I say think through this termination in advance, because you don't want to go out, terminate someone, realize, oh geez, I was supposed to give them notice or a severance payment. I didn't do that. Well, you're going to have an issue on your hands. So think through this in advance. Check all of these documents. Check, the employment agreement is probably the most pertinent one, but of course anywhere else, and see what you have to do. Do you need to give notice? Do you need to provide some sort of severance payment? Did you say, hey, we're going to pay out unused PTO or vacation, or how do we handle if there's stock we have to repurchase? All of those things should be figured out internally prior to the termination, so you aren't running afoul of these issues and you're well prepared to handle them. Now, we talk about separation release agreements a lot with our clients, and that's because they can help control risk. When are they appropriate? Well, let me back up to the risk piece. They help control risk because what they are is you are having the employee sign something releasing their claims against the company and officers, directors, all of that. So that is ideal, right? Especially when you want to kind of close the chapter on that employee and not have a potential threat hanging over your head. Do keep this in mind as an option. When you can use it is when you're giving the employee something more than they're already entitled to receive. So that means if your employee agreement said you already have to give them notice or severance, giving them that same severance they're already entitled to is not enough. It needs to be something more. And that more can be money. It can be keeping the company laptop. It can be, whatever you guys agree to, whatever makes sense, as long as it's more than what the employee is entitled to receive. So when you do that, you will be entering into an agreement that says, employee, we're giving you this. This is more than you were entitled to receive. You agree you've been paid all of your wages. You agree you have no other claims against us, and you agree that you will not ever be bringing, claims against us in court. Sign here. So that is a good way to handle that risk. It's not great in every scenario. If you've had an employee there for 3 weeks that was caught stealing on the job, do you want a severance and release agreement? No, you do not. Do you want it for a long-time employee that potentially has an age or race discrimination claim? Yes, you do. So think about that. Sometimes you have to decide, how much is this worth? Sometimes the employee wants a lot more than you're willing to give, and you might not be able to reach an agreement, but do consider it as an option. If you do it, there are special release considerations for age. Age requires that the employee have 21 days to review the agreement and 7 days to revoke. So just keep that timing in mind as well. All right, you've done it. You've thought through everything. You have analyzed the situation. Maybe you had a PIP and the person did not succeed. Maybe they've done something bad enough they didn't have one, but you have arrived at the termination meeting. What do you do? Well, first of all, you should schedule it in advance. It should be a set time, a set location, preferably with no one peeping in the windows. Nowadays with so many people remote, it can be done via Zoom. It can be done via phone call. We generally like to see it in person, but that's just not an option a lot of times right now. But you should schedule it, put it on the calendar, and consider having a witness there as well. Now, this isn't necessary in every situation, but it is generally helpful. And by having a witness, I mean having a neutral manager, third party there, just in case things go south later, you can have an extra set of eyes to say, here is what happened. Of course, being professional in the meeting, that goes without saying. You will want to remind your employee if they have obligations, for example, a non-solicitation confidentiality. So keep that in mind as well. And if you have an employee, if this is, things might be going real south real quick, cut off their access. In the middle of your meeting, have an IT person go and stop all of their access to email, to computers, to anything, so that way they cannot go back to their desk and send that hated company-wide nastygram, railing against how terrible the company is. Don't let that happen. There are some circumstances, of course, that aren't quite so contentious. And in those, consider doing an exit interview. And the reason for that is because you will learn more from a departing employee than one who's currently employed. All right, reasons. This is, goes without saying, but sometimes I think people want to be nice in their termination and don't want to tell the truth and call it a layoff or something. Don't do that. Be truthful. You can say, it's not working out. This is a problem. We're going to let you go. Or you violated these policies multiple times, or whatever the reason. Keep it short. You do not need to list every single reason, every incident. You just say, here's the reason why. They'll probably want to argue or say something about it. Briefly listen and exit the room. You are done. You don't need to get into a back and forth on this. What you do need to do is if the employee thereafter requests the reasons for the termination, you do have to provide those. And again, you'll want to be careful with how you kind of phrase that. So think that through before doing that, but you can't just ignore the employee after the fact if they're asking you for the reasons. But in the meeting itself, do keep it brief and of course, document what happened. I mentioned reminding the employees of their obligations before, and these can be, I've listed a few here. Non-competes, Shannon from our firm is actually talking about those tomorrow, our new Washington non-compete law, and when you can enforce those. And so the law has changed. They are not always enforceable. Your non-compete that you might have with existing employees might not be good anymore. So keep that in mind. Of course, if they have non-solicitation, confidentiality, returning of company property, this can also include, any intellectual property you have. You really want to keep an eye on that and don't let that just go out and have them take it with you. So keep that in mind and make sure you're getting back everything you need. All right, I said we talk about emergency terminations. What do you do? There will be a time where you cannot wait, you don't do the full think through. And for that, you always want to have a procedure in place. And this is, the things that I talked about before. Know and put a little checklist together. Are there company obligations for severance or for notice or things like that? What do we need to address? Have your IT person on standby ready to shut down access at a moment's notice if necessary, and know the steps that have to be done to do that. When you terminate, oftentimes there's, kind of an emergency reason, of course, which means tempers might be a little higher. Again, handling it professionally, having the employee potentially or escorted out if necessary. That's back to the non-remote days. And most importantly, you need to document this afterward. So you need to explain what happened and why, and make sure that's documented, because it's amazing how quickly you can forget some of these details. So do keep that in mind, that you should jot that down right away. I put some information here about final paycheck, just because this often paycheck. What do I do? In short, you do not have to have the final paycheck at the termination. It's just due on the next regularly scheduled payday. And so, whatever that's, if it's done direct deposit, that's perfectly fine. You cannot withhold that paycheck if they are keeping property. And that's even if they're keeping a laptop, if they're keeping, company information, you can't not pay them. So pay them and then argue about the other issues later. There are some circumstances where deductions are allowed. This is tricky. There are differences between deductions authorized for ongoing employees versus deductions from a final paycheck. So keep that in mind. And Ellen and I have some good information on this that you can walk through if you need to. And I do recommend walking through it every time this situation comes up because it is tricky and you don't want to get trapped into mistakenly withholding wages that you should not be doing that because then you'll be liable. In short, if it's for the employee's benefit, like, medical health benefits, things like that, a personal loan, and it's in writing, yes, you can deduct. And there are certain circumstances, and I listed a couple here. Those are, trickier ones. And so that's why I really recommend just keeping a close eye on that and looking at it if the scenario comes up. Okay, last slide here is what about post-termination considerations? Of course, you will have employees that will want to bring claims against you. Maybe they want to file an EEOC charge, maybe they have wage claims and litigation, whatever it may be. These things are always potentially on the horizon. So that's why you want to manage your risk if possible by thinking of whether a separation and release agreement is appropriate. Of course, you want to do everything right so you aren't faced with these, or at least you have good defenses, and that's why you've documented. But if you do have these potential claims, keep everything, of course, for the employee. Make sure you've kept all the documentation. If there are any emails you need to make sure to gather and stick in the file, do that and be prepared in advance so you aren't playing catch up if this claim comes to you. And that can mean, preparing internally, can mean talking to your counsel about, hey, we think this is coming, or we got a letter, how should we shut this down quickly and work through those options. Again, I mentioned securing company information because, now, especially with remote work, you have a lot less physical control over what's going on. And so you need to figure out how you can secure that information, what the employee's obligations are, and how you can do that. And following up with the employee if that's not happening, of course. And then on the company side, for the people, still working there, you want to make sure that company morale is handled as well. It's not just about the employee that's been terminated, but it's, okay, the people that are still here, how can we make our workplace better? How can we still want them to work with us? How can we help, say, hey, this happened, this was a termination, and we're sorry this happened, and we think you guys are great employees. We still want you here. We love this company, and it's because of you. It's because of our employees. And focus on that if necessary. You might have to answer some questions, not specifics, not details about the terminated employee, but really focusing more on the we felt like we needed to do this, but we're looking forward to positive future, and really put it back on thinking that you want them to want to work there and make it a positive for them. So those are the main things to be thinking about for terminations. Now that we're remote, now that we have COVID, now that we've got all sorts of considerations going on. Hopefully those were helpful. Thank you everyone so much. Appreciate your time.